From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Donald Trump fails to come up with a bond to appeal his civil fraud judgment of nearly $500 million as New York Attorney General Letitia James threatens to start seizing his properties. Meantime, 5 states are going to the polls today, with most of the focus on the Republican Senate primary in Ohio. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel, and editorial board member Kate Batchelder Odell. Monday is the deadline that Donald Trump faces to post a bond covering a judgment of $355 million, which has grown to something more like $450 million when including interest. And yesterday, this Monday, his lawyers sent to the court a filing saying that he had approached more than 30 surety companies proposing to pledge as collateral a combination of cash or cash equivalents, but the vast majority do not have the financial strength to handle a bond of this size or are unwilling to accept the risk associated with such a large bond. And according to New York Attorney General Letitia James, she will accept nothing less than the full amount. And here is what she was saying even back in February about what she planned to do if Trump did not meet this bond.
If he does not have funds to pay off the judgment, then we will seek, judgment enforcement mechanisms in court. And we will ask the judge to seize his assets. We are prepared to make sure that the judgment is paid to New Yorkers. And yes, I look at 40 Wall Street each and every day.
Alicia, what do you make of this, the legal options that President Trump might have, and that statement there by Letitia James?
Right. Donald Trump and his lawyers have openly said he really doesn't have that much liquid assets. He doesn't have the cash to actually post this bond to stop the state from enforcing this judgment. The alternative he has is basically he could sell off some of his properties, in which case he's going to be out of those properties. He's unlikely going to be able to reacquire them. I mean, maybe, but if he has to sell them off, it's going to be a fire sale. So he'll have to probably sell them off at a loss because that's just what happens. This is common when you're forced to unload property. You usually have to do it at a discount. So that's one option. The second option would be to actually, borrow or collateralize some of these assets to get a bond by what are called sureties, which are insurance companies. And there really aren't many that will actually insure or guarantee a bond for this large amount. The Department of Treasury actually has to kind of license these sureties to do that. Those that do say that they are unwilling to accept real estate as collateral. And that's basically all of Donald Trump's assets. So he really doesn't have many options right now to stop the state from enforcing this judgment.
A couple points here. One, Kim, that I think is worth making is that I read through much of this ruling, this judgment against Donald Trump, and I find some of the business behavior kind of hard to defend, inflating his assets, including things that are apparently easily checkable, like tripling the size of his Trump Tower triplex, the square footage of it on these financial statement forms to banks. On the other hand, a $450 million judgment, essentially, in a case where the banks are not complaining that they lost money, is really a staggering number. And number two is that he has to post this in order to appeal the ruling. But the reason that you make defendants post bonds, or at least one reason, is to prevent them from trying to shield their assets and do these financial maneuvers while the case is on appeal. And here, I wonder whether that is really a risk, given that part of the judgment was also installing this financial monitor at the Trump Organization. So I wonder if they can really move assets around in a way that would put this judgment at risk in the first place.
Yeah, I mean, look, you put your finger on all kinds of the problems that are now present in this final judgment that was made about the amount of money that needs to be put forward. For one, as you said, you already had a portion of this judge's ruling that says that a person is now going to be watching what's happening day in and day out. So in theory, that mitigates the risk of there being any funny business business as this case moves its way through appeal. But the issue about the staggering sum, the legal term for this is excessive fines. And it's a very serious legal topic, one that has spent a lot of time in courts and has a long history in the United States, given that you can go all the way back to the Magna Carta in England. Scholars and legal professionals worried about the state's ability to use excessive fines as a way of essentially crippling people. And I think one of the things that's very disturbing about this particular judgment as well is that the logic that the judge used to come up with the number that high is also so faulty. For instance, one of his arguments was that Trump had experienced interest rate savings as a result of these false documents. But there's not a lot of evidence that he did actually profit out that, given that the banks didn't seem to alter their loan terms on the basis of what was submitted to them. Another argument the judge made is that there were profits made based on these false statements, but there's no evidence that the statements themselves enabled that profit that came in the end. And so it's very, very faulty logic to come up with an extraordinarily huge number. And this gets to the point of, if you are then also putting that roadblock in the way of being able to even question any of these underlying assumptions, that seems to be legally very problematic as well, too.
Hang tight. We'll be right back with more on this in a moment. Welcome back. Let's take up this question of excessive fines as a legal argument that President Trump might make, and that derives from the U.S. Constitution in the Eighth Amendment, which says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And there was an interesting Supreme Court case a few years ago, 2019, where the question was whether that excessive fines clause applied to the states. And the ruling by the Supreme Court was yes, it did. This case was called Timms v. Indiana, and it was about a guy who was caught selling heroin. The maximum fine that he faced under the law was $10,000. And yet what happened was the police seized also his Land Rover, which was valued at $42,000. So he appealed all the way up to the Supreme Court. The Supreme Court said that this excessive fines prohibition does apply to the states. And then ultimately, I believe the Indiana Supreme Court said that that Land Rover seizure was grossly disproportionate to the crime committed and the culpability of the Land Rover in that crime, and the gap between what he was able to be penalized with under criminal law and the seizure of his property. Alicia, is that something that Donald Trump might be able to make an argument to a court? And would he be able to get that somehow into federal court if the New York courts are not open to that argument?
Well, he actually is making that case in the legal filings and the appeal to stay the judgment. He makes the argument that both the $464 million judgment is an excessive fine, as well as the requirement that he post that bond. Otherwise, the state will seize his assets. He says this is excessively punitive, and I think he has a strong argument. On one hand, as he points out, nobody actually lost money. None of the banks who lent him money, they all said that they had done their own underwriting, that their loan terms and conditions were not actually based, at least primarily or in large part, on his financial statements that he allegedly fudged. So that's one thing, is that there weren't really any actual victims here. Two, the way, as Kim was pointing out, the way that this sanction was calculated is disproportionate to, again, this wasn't a criminal case. This was a civil case to any offense that he committed under the law. And that, yes, there were some inaccuracies, there were some misrepresentations, but $464 million is excessive. It maybe done Mr. Trump a few million, maybe. But $464 million, which would essentially, again, require him to sell his assets or would deprive him of property, that is overkill. He does have a compelling argument. Whether this will actually be countenanced by the New York courts is a different question. The New York state constitution does have an excessive fine clause as well. So I'd imagine he could appeal this all the way up to the New York Appellate Court, which is its version of its own Supreme Court. And if he doesn't get a ruling in his favor, he could technically appeal to the U.S. Supreme Court. Now, I don't think Chief Justice Roberts is eager to weigh into another Trump case, but this is such an egregious overreach, they may have to.
What about the political effects of this, Kim? I mean, one way or another, I have a hard time thinking that it doesn't buoy Trump's political argument that he's being targeted, either if he is successful in that argument and some Supreme Court, whether it's the New York courts or the U.S. Supreme Court, decides to wade in here and pause this judgment, at least while they hear this case, or if he's unsuccessful and he's not able to come up with this bond, he can't appeal the ruling. The New York Attorney General starts seizing his real estate. It seems to me that that is adding to the argument that he is making to the public in this presidential election.
Even honest Democrats, at least in quiet, are willing to admit that there are some real problems with not just the quantity of these suits that have been brought against Donald Trump, but obviously the lack of quality of them as well, too. And in Letitia James, you remember, we also have a prosecutor who ran for election saying that she was going to bring a suit and who seems to be on a vendetta against Donald Trump. It's very easy for him to take a couple of sound bites of her saying these things, put them in an ad, or repeat them to the audiences that are coming out to hear him campaign and persuasively make the argument that he is being attacked and has become the target of a vast lawfare campaign against him. And it isn't just Letitia James, it's hers, it's Alvin Bragg's in New York. It's the sweeping nature of the case that was brought in Georgia on conspiracy charges, wrapping in, more than a dozen people. And now the drama of that and Fani Willis, the prosecutor, and the affairs she was having with the special counsel she'd brought in. I mean, the whole thing looks problematic and it looks political and partisan. And if I were Jack Smith, the U.S. prosecutor, who, might in fact have a pretty solid case when it comes to some questions about the documents, maybe, at least of all the cases, that one has got a little bit more behind it. I note that former Attorney General Bill Barr thinks that Donald Trump has some actual liability in that case. If I were he, I would be frustrated by all these other cases that have been brought because everything ends up getting lumped into one category and all of it viewed by many voters out there as overkill and partisanship.